My name's Nicole Busby. I'm a Professor of Labour Law at the University of Strathclyde. The Charter of Fundamental Rights of the EU is part of the European Union's constitutional law and has been since 2009, so it has the same legal status as the treaties themselves. It's been described as a catalogue of rights because it brings together the civil, political, economic and social rights of the EU that apply to EU citizens and all of those who reside in the European Union. Although it doesn't in itself provide any new rights, it articulates the existing rights under the body of European law. And so it provides a very important function in that it makes those rights clear and expressed, if you like, in European law, so that those who they apply to and others are aware of the rights and principles and what their scope is. It consists of a number of statements which are divided under 6 chapters: dignity, freedoms, equality, solidarity, citizens' rights and justice. It encompasses the European Convention on Human Rights, which is an international instrument, but its scope is actually broader than the Convention. So it contains all the same protections that the Convention contains, but also some others, specifically in the area of social rights and also non-discrimination. And it actually fulfills a very important function in that it kind of plugs European law into the international law that is provided under the Convention itself. So that function is actually very important. In terms of its scope, it's very wide. It contains lots of different areas, including rights regarding the prohibition of slavery and forced labour, data protection, and also a number of key workers' rights. So the scope is broad and wider, in fact, than the Convention itself. If the UK leaves the EU, the provisions of the Charter will cease to apply to UK law if we have what's been termed as a hard Brexit, unless there is express agreement to the contrary. That won't make a difference in the short term necessarily if the existing rights are guaranteed under UK law, but in the longer term we could see a reduction or a diminution, if you like, of the rights, the protections that are currently guaranteed under EU law. And that's quite worrying, I think, for many of us who work in this area. This would place greater emphasis on the instruments that provide, or where the rights that are contained in the Charter are drawn from. So, for example, the Convention itself, but also domestic law, such as the Human Rights Act. But what it would also do is leave the path clear for a radical overhaul of human rights legislation at the domestic level. And again, that's a matter of concern for many of us in the area. Can Scotland do anything to protect the rights that currently exist in the event of a hard Brexit? I think to some extent, yes, there is some potential there. Scotland could certainly legislate on those issues which are defined as human rights areas, but in areas such as equality or equal opportunities and employment, those issues are actually reserved. So legislative competence rests with Westminster, making it difficult for the Scottish Parliament to do anything specific. Also, we would lose the protection that when EU law is interpreted, currently the Charter provides that it must be interpreted in light of the provisions of the Convention on Human Rights, and that protection would go. And that's of concern because the Charter is relatively new to the EU law, but it is beginning to show its potential, particularly through the case law of the European Court of Justice. So we're seeing cases brought, for example, in the area of parental rights and other areas of workers' protections, where the Charter is being used in ways that I think show its full potential, which hasn't yet been reached. And the UK, of course, if it leaves the EU, will lose out on any future potential that the Charter has for preserving and protecting human rights and equality rights.